Okay, so here's what happened. I need you to understand this is not speculation. This is not anonymous. Sourcing. This is court record. Documented time stamp witnessed by 17 people in that courtroom. February 3rd, 2026, Federal Courthouse, Southern District of New York, 9:47 a.m. Eastern Standard Time. The Honorable Judge Catherine Walston presiding, criminal. Case number 24, CR 459. United States of America versus Donald John Trump, pretrial motion hearing. Routine, right? Except nothing about. This was routine because at 9:47 a.m., Judge Walston enters the courtroom. The bailiff announces whole rise. Standard. Protocol. Everyone stands. Defense. Cushion stands. Gallery stands except one person. Donald Trump seated, arms crossed, staring straight ahead, not moving. Judge Walston pauses at the bench. She waits 5 seconds, 15 seconds. The entire courtroom is frozen. She says, quote, "Mr. Trump, please stand for the court." He does not move. She repeats it. "Mr. Trump, stand for the court." Nothing. 30 seconds now. Then, and this is where it gets absolutely unprecedented, Judge Walston makes eye contact with the lead U.S. Marshal, Chief Deputy Marshal Robert Kenner. She nods. He steps forward. 2 additional marshals move toward the defense table. This is happening in real time. In a federal courtroom in the United States of America, the standoff lasts 6 minutes and 12 seconds, documented, timed by 3 separate court reporters. And here is why this matters. Because what happened next isn't just contempt of court. It's a constitutional detonation. And watch the space. But first, and I mean this, if you care about the rule of law, if you believe no one is above the system, you need to stay informed right now. Subscribe, hit that notification bell, because what's unfolding in these courtrooms is not background noise. It is the central drama of our republic, and you need to see every single move, every filing, every consequence. Subscribe now, because this story is just beginning. So let's go to the paper trail, because this is where it gets legally catastrophic. Court transcript, Southern District of New York, case number 24. CR 459, page 47, line 12. Judge Wilson states for the record, quote, "The defendant has refused a direct order from this court to stand. Chief Marshal Kenner has approached the defense table. At 9:53 a.m., page 48, defense attorney Todd Blanche interjects, quote, Your Honor, my client is exercising his First Amendment right to Judge Walston cuts him off. Quote, counsel, your client is in contempt. This is not a First Amendment issue. This is courtroom decorum, basic respect for the judicial process." The transcript shows Blanche tries again. "Your Honor, if I may." She shuts it down. "You may not, Mr. Trump will stand or he will be removed." Now, here's what we know from the sealed Marshal Service Incident Report, obtained by ProPublica on February 4th. Chief Deputy Marshal Kenner testified in a subsequent emergency contempt hearing that at 9:54 a.m. he verbally instructed Trump, quote, "Sir, you are required to stand. This is a federal order." Trump's response, according to 3 witnesses, including 2 assistant U.S. attorneys and 1 courtroom deputy, was, quote, "Make me." 2 words. Documented sworn testimony. "Make me." The marshals did not physically touch him. Protocol, they cannot escalate to physical contact without explicit judicial authorization. So Judge Walston issues that authorization, page 5, one of the transcript, quote, "Chief Marshal, you are directed to ensure compliance with this court's order by any lawful means necessary." At 9:56 a.m. Trump stands. But, and this is critical, he does not do so willingly. According to the incident report, he stood only after Marshal Kenner placed his hand on Trump's shoulder and applied what the report describes as, quote, "minimal guiding pressure," that is, physical contact between a federal law enforcement officer and a criminal defendant in open court, because the defendant refused a judge's direct order for 6 minutes and 12 seconds. Tick-tock. Now let's talk about what happened immediately after, because the fallout inside that courtroom was absolute legal chaos. Judge Walston, once Trump finally stood, did not proceed with the hearing. She suspended it. Page 54 of the transcript. Quote, "We are in recess. Mr. Trump, you are hereby held in contempt of this court. Sanctions to be determined at a hearing scheduled for February 10th at 10 a.m. BAIF, clear the courtroom." The prosecution team, led by Assistant U.S. Attorney Jennifer Moore, files an emergency motion within 90 Minutes. Timestamped 11:23 a.m. The motion, which is now public record, requests, quote, immediate pretrial, detention pending psychological, evaluation of the defendant's fitness to participate in further proceedings. Read. That again. The United States government is asking a federal judge to detain a former president because his behavior in court suggests he may not be mentally competent to stand trial. The filing cites Federal Rule of Criminal Procedure 18 subsection 2, competency to stand trial. It argues that Trump's refusal to follow basic judicial orders demonstrates, quote, an inability or unwillingness to understand the nature of the proceedings against him or to assist properly in his defense. The defense response filed at 4:17 p.m. that same day is 11 pages of pure defiance. Todd Blanche writes, quote, the government's motion is a transparent attempt to weaponize psychiatric evaluation as a tool of political persecution. President Trump's decision to remain seated was a principled act of protest against an illegitimate prosecution. But here's the proverbial smoking gun buried on page 7 of the defense filing. Blanche admits in writing that Trump, quote, made a calculated decision to challenge the court's authority as a matter of conscience. A calculated decision to challenge the court's authority that is not a fitness defense. That is an admission of intentional contempt and the prosecution. Pounce. Supplemental filing February 4th, 6:40 p.m. Quote, defense counsel has now confirmed what was evident to all present. The defendant knowingly, willfully, and deliberately defied a direct judicial order. This is not protected speech. This is criminal contempt. Wait for it. So where does this fit in the grand sweep of American history? Because we have seen presidential defiance before, but not like this. Not in a criminal courtroom. Not with marshals approaching the defendant. Let me take you back. Watergate 1974. Richard Nixon defied court orders. Yes, but through legal maneuvers, through appeals, through executive privilege claims that went to the Supreme Court. He never personally stood in a courtroom and refused a judge's direct command. 1987 Oliver North took the Fifth Amendment. He invoked constitutional protections. He followed courtroom protocol even as he stonewalled investigators. He stood when the judge entered. He said, yes, Your Honor, and no, Your Honor, go back further. Tap Dome 1924. Albert Fall, Secretary of the Interior, convicted of bribery. He showed up to court. He stood for the judge. He participated in the process, even as he maintained his innocence. Aaron Burr, 1807 treason trial. Thomas Jefferson's former vice president, accused of conspiracy to create a separate nation in the Western territories, burstewed for Chief Justice John Marshall. He engaged with the legal system. He didn't refuse to rise, and I spoke with Professor Lawrence Tribe, Harvard constitutional scholar. February 4th, he told me, quote, in 238 years of American jurisprudence, I cannot find a single precedent where a defendant in a federal criminal trial physically refused a judge's order to stand and required martial intervention to comply. This is sui generis, unique, unprecedented. Professor Tribe continued, quote, the implications are staggering. If a defendant can defy the basic rituals of judicial authority without immediate and severe consequences, the entire architecture of the rule of law begins to crumble, not hyperbole, structural collapse. Norman Eisen, former White House ethics star, former House Judiciary Special Counsel. During the first Trump impeachment, I reached him February 5th. He said, quote, what we witnessed was not just contempt of court. It was contempt for the constitutional order. The judiciary is a co-equal branch. When you refuse to stand for a federal judge, you are refusing to acknowledge the legitimacy of that branch. That is insurrectionary logic. Insurrectionary logic. Those words and the political fallout. It has been swift and it has been seismic. Within hours of the incident, Senate Minority Leader Chuck Schumer issued a statement February 3rd, 2:14 p.m. Quote, what occurred in that courtroom today is a disgrace to the office Donald Trump once held and a stain on American justice. No person, regardless of their former position, is above the law or beyond the reach of judicial authority. The Senate Democratic Caucus stands firmly with Judge Walston and the integrity of our federal courts. Senator Mitt Romney, one of 7 Republicans who voted to convict Trump during the second impeachment trial, spoke to reporters outside the Capitol. February 3rd, 6:30, 8 p.m. Quote, "I am deeply troubled. If these reports are accurate, this behavior is indefensible. Our system depends on respect for the judiciary. Without that, we have chaos." But here's what's even more telling: the silence. 24 hours after the incident, only 3 Republican senators had issued any public comment. 3 out of 49. Senator Lindsey Graham, when asked directly by CNN's Manu Raju on February 4th, said, quote, "I wasn't there. I haven't seen the transcript. I'm not going to comment on something I didn't witness. That is not a defense. That is evasion." Senator Josh Hawley, who famously raised his fist to January 6th rioters, tweeted at 11:51 p.m. February 3rd, quote, "Another day, another weaponized court. President Trump is standing up to tyranny. Standing up, he literally refused to stand up. The irony is so thick you could cut it with a subpoena. Meanwhile, legal experts are wargaming what happens next. The contempt hearing is scheduled for February 10th. Judge Walston has a range of sanctions available: monetary fines, which for Trump meaningless. He'll fund, raise off at community service. Unlikely in a federal criminal case. Or, in this is the nuclear option, incarceration. She could order him held in custody for civil contempt until he purges the contempt by apologizing and committing to follow court orders. Or she could refer the matter to the U.S. Attorney for criminal contempt charges, which carry up to 6 months in federal prison per count. Former federal prosecutor Renata Marati told MSNBC on February 4th, quote, "If Judge Walston does not impose serious consequences here, she signals to every future defendant that judicial authority is optional. That is untenable. So let's bring this home, because what we are watching is not an isolated incident. It is a stress test of the constitutional framework. Article 3 of the United States Constitution establishes the judicial branch as a co-equal power. The Judiciary Act of 1789 gave federal courts the authority to enforce their own orders through contempt powers. This is not new law. This is foundational architecture. 237 years of precedent, and it rests on one simple premise: that everyone who enters a courtroom, from the poorest defendant to the most powerful former president, submits to the authority of the judge, not as a person, as a representative of the law itself. When Trump refused to stand, he was not defying Catherine Walston. He was defying the Constitution. And here is the moral stakes for the Republic. If we allow this to pass without consequence, we establish a new precedent. That power insulates you from the basic obligations of citizenship. That fame or wealth or political influence grants you immunity from the rules that bind everyone else. We have seen this story before. Not in America, in other places, in other times, where the rule of law eroded not in one dramatic collapse, but in 1,000 small capitulations. A judge who doesn't enforce contempt, a marshal who hesitates, a political class that looks away. Republics die not with a bang, with a whimper. But here is what gives me hope. Judge Walston did not whimper. She did not hesitate. She enforced her order. The marshals stepped forward. The system held. For 6 minutes and 12 seconds, we were on the edge. And then the defendant stood. Not willingly, not gracefully, but he stood because in that courtroom, in that moment, the law was stronger than his defiance. February 10th, 10 a.m., Southern District of New York, contempt hearing. The whole world will be watching, because what Judge Walston decides will answer a question that should never have to be asked in America. Is anyone above the law? We are about to find out. Watch this space. And I mean it. Stay with this story, because the next chapter is already being written. Subscribe. Stay informed. Stay vigilant. The Republic depends on it.